Good morning, everyone, and welcome to this TemPro UNHCR webinar on cessation of refugee status in the Nordic region. My name is Jessica Schultz. I am a senior researcher at the Christian Michelsen Institute in Bergen, Norway, and I am the head of the TemPro project together with anthropologists and legal researchers in Denmark, Norway, and the UK. And basically, this project is about mapping how temporariness affects both asylum and immigration law, and also the lived experiences of refugees in those countries. And so, because cessation is such an important aspect of our work in the project, I was delighted to have the opportunity to co-host this seminar together with UNHCR, the regional office, the Nordic and Baltic regional office. In particular, Olivia Mocanasu was one of the initiative takers for this webinar as well. What we will do is, we have a large panel today. We will first hear a number of presentations about country studies and regional developments, and then have comments by two expert commentators who I'll introduce shortly, and then we'll have a Q&A session. And the webinar will be recorded and available by tomorrow at the Bergen Global website, bergenglobal.no, and I can send the link also out to those who have registered. I encourage you to submit any questions using the Q&A function on Zoom. That makes it easier for us to keep track of them. And yeah, and any other sort of housekeeping issues you can use on chat. So this is the plan. First, we will hear from Gisela Thater, who is Senior Legal Officer for the Nordic countries at UNHCR. She'll be giving us kind of an introduction into cessation, the concept of cessation and regional developments. Following Gisela, we'll be hearing from me. I'll give you an overview of developments and dilemmas in Norway. After me, we'll have Nick Tan, who's a researcher at the Danish Institute for Human Rights in Copenhagen, and author of a recent publication on the paradigm shift and cessation practice in Denmark, which has been linked to in the announcement for this webinar. So you can take a look at that afterwards if you haven't already. And then finally, we'll hear about Sweden from Peter Varga, who is a legal officer and focal point for Sweden at UNHCR and has also worked as an asylum attorney, both nationally and also before the European Court of Human Rights. We are very lucky today to have two truly expert commentators. We'll be hearing from Jens, who is a researcher with the TemPro project. Jens Vedsted Hansen is a professor at Aarhus University in asylum and immigration and human rights law, and he has also been involved in another similar initiative looking at temporary asylum and cessation in the Scandinavian countries. And we have also linked to the report from that project in the announcement for this webinar. And you can hear a very interesting webinar based on that report also that we've linked to from the TemPro website, but which was conducted at Institute for Social Science Research in Oslo a few weeks ago. So while that webinar really focused on policy developments, in this webinar, we're taking a little bit more of a structured legal approach. So hopefully the two events will complement each other very well. And then last but not least, all the way from Melbourne, we have Maria O'Sullivan, who is senior lecturer at Monash University and the author of this excellent book on temporary protection and cessation. So we are really lucky to have an international expert giving her perspectives on what's going on in Scandinavia as compared to kind of the international safeguards and standards developed with respect to cessation. Yes, so without further ado, let us start with Gisela. We will, share her slides. Yeah.
Yes, thank you very much, Jessica and CMI. We are really happy to be a part of this webinar. I and my other two colleagues from the UNHCR representation for the Nordic and Baltic countries. No, as a presenter, I've been asked to set the scene and will give you a brief overview of the international framework governing the ending of international protection, including cessation. But before doing so, I would just like to recall UNHCR's rationale for engagement on this issue. As you know, we have a global mandate from the UN General Assembly to supervise the application and interpretation of the 1951 Convention. So our interest in this important topic is really to promote and preserve a correct use of the 1951 Convention and other relevant refugee law instruments. Our office here, based in Stockholm, I'm calling in from Stockholm. We develop UNHCR's positions on the developments in the region in close coordination and together with the Division of International Protection and our Regional Bureau for Europe to ensure global consistency and, of course, the best possible quality. So next slide, please. Well, we just heard earlier this week that global displacement has just passed the 80 million mark with continued new displacement despite the ongoing pandemic. Our region has, in contrast, this year seen the lowest number of arrivals in decades. And in parallel, we see restrictive policies and practices continuing on a number of fronts, including an increased use of cessation of refugee status. Perhaps Denmark is one of the most explicit cases in point, which in early 2019 introduced a regular mandatory review of protection needs applicable to all beneficiaries of international protection. We will hear more, as you, Jessica, said, on the developments in the respective countries. So I will just flag for general trends of particular concern to UNHCR. The first one is that cessation of refugee status has taken place where the changes in the country of origin has not been fundamental, stable, and effective, or have not been properly assessed. Denmark, again, is an example. Denmark in 2016 lowered the threshold for the withdrawing or not renewing of subsidiary protection, so allowing for cessation when the security situation remains fragile and unpredictable. The other second point seen, for example, in Norway, is that cessation has been applied where the changes have only taken place in parts of the country and the applicant is considered to be able to return to a particular part of the country. So instead of making a cessation assessment, an internal flight assessment is carried out. The third is that protection status has been seized merely due to a change in personal circumstances of the applicant, not necessarily because the situation in the country of origin has improved. In Sweden, for example, we've seen young individuals whose status have been seized as they turn 18, merely because of the change in their age. We see a similar development in Norway and Iceland, where status is seized owing to a change in the personal circumstances without necessarily looking at the changes in the country of origin as well. A fourth trend, we've seen this for quite some time, is that refugees have their status seized if they commit a crime. Something we see, for example, in Norway and in Finland, and this may occur for serious as well as less serious crimes. And all these trends are problematic from a refugee law perspective. Can we move to the next? Refugee status, international law, is in principle meant to be temporary. International protection is really only needed for as long as the reasons for fearing persecution persists. And the 1951 Convention also recognizes this, that refugee status can end under certain clearly defined conditions. So this also means that once a person is determined to be a refugee, he or she keeps his or her status, unless they fall within the terms of the cessation clauses or their status is cancelled or revoked. I'll come to these terms in just a bit, but these are really the only three grounds, according to international law, that can end status. And because of the serious consequences for the individual, the ending of international protection has to follow a very rigorous process with safeguards and so on. And for the same reason, the criteria for cessation should be interpreted restrictively and exhaustively. So the next slide. So to make sure that the ending of protection status is in line with international standards, it's really important to keep the distinction between these three concepts clear. These terms are not fully covered by explicit provisions in the 1951 Convention, except for cessation and the qualification directive of the EU. And UNHCR has in its comments on the qualification directive requested states to differentiate between these concepts and the legal requirements that are attached to them. So cessation refers to the ending of refugee status according to Article 1C of the 1951 Convention, because refugee protection is no longer needed or justified for one of the reasons that are listed in that article. These clauses have also been incorporated into the qualification directive. More on this a bit later. Cancellation, on the other hand, means a decision to invalidate a recognition of refugee status, where it's later established that the person should not have been recognized in the first place. For example, if a particular fact had been known at the time of the initial decision, including in cases where the applicant should have been excluded from refugee protection, or where he or she in fact did not meet the inclusion criteria. So the status was incorrectly granted because of misrepresentation of facts, fraud, bribery, or other such conduct on part of the applicant, or because the determining authority made an error in law or on fact. The 1951 Convention doesn't contain any explicit cancellation clauses, but from UNHCR's point of view, we see such a practice as being fully in line with the convention, because it's not the purpose of the convention to give protection to people who don't need it or who do not deserve it. So revocation refers to the withdrawal of refugee status in situations where a person who was initially properly determined to be a refugee, but subsequently engages in such serious conduct that it falls within the exclusion clauses in Article 1F or C. So this is about war crimes, crimes against humanity. But note here, very importantly, that conduct falling under Article 1FB about serious non-political crimes, they do not constitute such conduct that can give rise to revocation, as this provision is limited to crimes that were committed prior to arrival in the asylum country. So such crimes ought to be dealt with by the national justice system, the prosecution, etc. But the remaining clauses in Article 1F, they are not explicitly limited to acts committed before arrival, before refugee status was granted. They are about such serious crimes that they apply regardless of when or where the acts were committed. So they can thus form the basis for revocation of refugee status. There is more to be said about this, but we have limited time, so maybe we can cover. But these provisions are not to be confused with the exception to non-refoulement in Article 33.2 of the Convention or Article 32 of the Convention. They serve a different purpose and they do not end the refugee status of the person concerned. So next slide. When it comes to cessation, this is permitted when the criteria in Article 1C 1 to 6 are met. So the first 4 provisions cover voluntary acts of the individual. So re-establishing yourself in the country of origin or acquiring a new nationality. Whereas the last 2 provisions relate to cessation because of a significant change in the circumstances in the country of origin, removing the reasons for granting protection. Next. As further explained in UNHCR's executive committee's conclusions and also in a number of guidelines, in particular guidelines on international protection number 3, in order to apply cessation based on the circumstances clauses in Article 1C 5 and 6, the changes need to be fundamental, durable and effective, or in the very similar words of the qualification directive, changes of a significant and non-temporary nature. So changes that are only temporary or only affect a part of the country cannot lead to cessation. Importantly also, it is the state that has the duty to demonstrate or ascertain that the changes are fundamental and durable and so on, that the criteria for cessation are met. Next. There has been a long-standing understanding that the ceased circumstances in Article 1C5 refer to changes in the country of origin. In recent years, we have seen, however, emerging state practice that are adopting both wide and restrictive interpretations of circumstances. Some encompass also personal circumstances. A simple reading of Article 1C5 does not give the answer to this question, but UNHCR recognizes that personal circumstances can't be ignored in the context of cessation. They have contributed to the recognition of the need for international protection. In fact, it's often a mix of the two, a combination of the general conditions in the country of origin and the personal circumstances or characteristics. So we don't exclude that personal circumstances may be part of the assessment, but they always need to be assessed together with the changes in the country, never in isolation. And importantly, the changes always have to be fundamental and durable. So, and then just the last point before I stop, we've seen in Denmark and also in Sweden, cessation applied to individuals with subsidiary protection. And in UNHCR's view, because of the similarities, the principles for refugees and in Article 1C can, by analogy, usefully be guided also when applying cessation to beneficiaries of subsidiary protection. So as you see on these slides, Article 1C as well as the relevant provisions in the qualification directive have similarities, and the Court of Justice of the European Union has for its part also concluded that the requirements under the 1951 Convention need to be taken into account when interpreting the relevant provisions of the qualification directive, which deals with the ending of protection. Thank you very much from my side.
Thank you, Gisela. And I'm glad to see we already have questions coming in the Q&A. Please feel free to make note of questions you have underway. And that was a really useful overview that you provided us about the cessation concept and also developments in the Nordic region, which I can sign under as being relevant in the Norwegian context, all 4 of those developments we see here. In my presentation, I will focus on, let's see if I can, yes. Is that working? Yeah. I'll be focusing on, I think almost everything Gisela had mentioned, with the exception of the blending of the revocation and cessation concept. In other words, cessation as applied in cases of refugees with criminal records. But we can discuss that in Q&A if there's interest in that particular problem. In my presentation, I will be giving a brief background for the increased focus on cessation in Norway, an overview of current practice and developments, and then conclude with some reflections on the gaps between Norwegian practice and international legal safeguards like the ones that Gisela had mentioned. I think one thing that maybe makes the Norwegian case a bit unique is the fact that cessation law and practice has really developed within the context of the 1951 convention. So while neighboring states and other countries have focused on cessation of people with so-called complementary protection status or subsidiary status. In Norway, cessation and the cessation criteria apply equally and have been applied equally to refugees, no matter what the source of their protection status is. So I think that's an important distinction. As with other countries in the region, the increased focus on cessation really intensified, I would say, following the increase in asylum applicants in late 2015. What happened, I think it was November 2015, there was a parliamentary coalition who proposed a list of restrictive measures in order to deal with the so-called crisis, including the possibility of assessing current protection needs of people with temporary residence permits. The cessation criteria themselves are part of the Immigration Act. They mirror UNHCR's criteria, and they've always been there. They're applied by the Immigration Directorate at the first instance, then the Board of Immigration Appeals, and finally by the courts, including, and this is significant, the fact that the Supreme Court of Norway has considered cessation cases already 3 times, once in 2010, twice in 2018, and now, as I'll be discussing later, there will be another case in January of 2021. Prior to 2016, when a new instruction came into force by the Ministry of Justice, which has the power to instruct the immigration authorities on the interpretation of the convention, cessation was really rarely used. It was a kind of or discretionary provision, and mainly because it was such a hassle actually to apply, was limited in its application to refugees with criminal records. And the reason why it was applied so infrequently was that it's, first of all, a complicated legal assessment, and also the fact is that most people have alternative grounds of residence anyway, so it was seen as kind of impractical. In 2016 came the first of 3 or 4 instructions by the Ministry of Justice, which really have shaped cessation practice in Norway. These instructions require immigration authorities, that is UDI, or the Immigration Directorate, to consider cessation in several different circumstances. First, when conditions in a certain country of refugee origin have changed to a significant extent, making it safe for many refugees to return. Second, when people apply for permanent residence. And And they've also, the instructions have also talked about like who is subject to these cessation or these protection reviews in a sense. And the instructions limit that to refugees with temporary residence permits. Unlike, as we'll hear in Denmark, resettled refugees resettled from third countries are excluded from cessation, as well as refugees who have been accepted as refugees in a sort of max influx situation, although that hasn't really been applied. The instructions say that internal flight alternative or the internal protection alternative may be applied in the cessation context. And the last set of instructions in 2019 have noted that former minors, so people who received refugee status, at least in part on the basis of a child-sensitive assessment of their protection need, can risk cessation at the age of 18, but cessation should not be initiated by the immigration authorities on that basis alone. But clearly, the fact that former unaccompanied minors, for example, risk cessation raises a lot of questions about the right to stability for children when they are assessed for protection. In addition to the cessation criteria themselves, there have been other recent changes to Norwegian asylum and immigration policy that have a direct impact on the scope for cessation practice. One that's really important in the Norwegian context is the increased scope for IPA, internal protection alternative application, that also came into play in 2016 when the reasonableness test for internal relocation was removed from Norwegian law and practice, which means that refugees may now be returned to their countries of nationality or previous residence as long as there is a safe area in their country of origin, no matter how unreasonable it might be for the individual or their family, including how unreasonable it might be to actually resettle and have a livelihood there. And then another development which has direct relevance for cessation practice relates to new requirements for permanent residence, making it more difficult for people with temporary status to receive permanent residence. These include the introduction of language requirements and income requirements, as well as a direct extension of the time that you must be resident in order to apply for permanent residence. And this was passed just this week. The previous period of 3 years has now been extended to 5. So because cessation in the instructions is linked to the residence status, temporary residence status, this means that everyone will be exposed to the possibility of cessation for a longer period of time. And then those refugees who are never able to meet the requirements for permanent residence could be sort of indefinitely exposed to the possibility of cessation if their situation or the situation in their country of origin changes. So far in Norway, cessation practice has mainly impacted Somali refugees. In 2016, about 120 Somali refugees were already warned that their status would be reviewed. As of this month, about 1,400 cases involving Somali nationals have been assessed. The vast majority have been set aside because it's likely that the refugee has other grounds anyway on which to remain. In general, caseworkers at the immigration authorities have told me that the Somali refugees whose continued protection needs have been assessed generally fall into one of 3 categories. Either they have independent claim to refugee status, including, for example, the risk of FGM for any minor daughters in the family, family reunification possibilities, and also humanitarian considerations. So Norway also has a provision in its Immigration Act, which provides residence for people with strong humanitarian reasons for remaining in Norway. And it's here that best interests of the children are concerned. So children's best interests in the Norwegian context are kind of separated from the protection assessment and instead considered in this parallel assessment of whether strong humanitarian considerations apply. And that's important because it means that the best interests of children will be weighed against immigration control considerations, and often they are seen to yield to those considerations. So the positioning of children's interests in the humanitarian sort of discretionary provisions of the Immigration Act have a direct consequence for the robustness of protection of children in this context. We have seen, there has been a few reports written already about the consequences of the threat of cessation and actual cessation practice on the Somali community, which point out the levels of insecurity, the health consequences, the consequences for employment, education, consequences in terms of trust in authorities, the ability to maintain those transnational networks that are so important for a successful eventual return and reintegration, et cetera. And I will give you some links to those sources of those studies. But that's also part of the project that we're working on in TemPro, is to try and dig a little bit deeper into the influence of cessation and other forms of temporality on people's lives. And what I think is ironic in Norway is that despite the fact that Somalis and changes in the country of instability in the country of origin for Somali refugees have been so prominent, the prominent focus of cessation practice, the principles of cessation law in Norway have basically evolved through this other kind of parallel set of cases involving single Afghan women who come to Norway, sometimes with children, and then are later joined by their partners in Norway. And it is the fact of their partner's arrival which triggers the cessation process. And the most well-known case that is still ongoing 6 years later is the so-called Farida case, which involves an Afghan woman who came to Norway with her daughter Farida in 2011 and was joined by her husband in 2012, her partner. And she was originally granted protection because her home area was considered too insecure. But she was able, and she was not able to be returned to an internal protection alternative because she lacked a male network in the area of return. So because her husband joined her, she was no longer unable to return to an internal protection alternative. But interestingly, the first Farida cases were based on the argument that the whole family could return to their district of origin in Afghanistan. So the first kind of principal finding when this case came to the Supreme Court in 2018 was that the immigration authorities had failed to determine that significant and stable changes were present in the home district in Afghanistan. So the case was remanded to the lower courts, who then based their subsequent decision on the fact that Farida and her family had an internal protection alternative in Kabul. Most recently, the Borgarting Appeals Court in the summer decided that an internal protection alternative is consistent with cessation practice. There's no reasonableness requirement. And also that significant and stable changes can hinge on relational factors. For example, the reunification of the family members. And this is really a distinct kind of cessation practice than, for example, other individual circumstances cessation practices, because those often relate to a change in political opinion or a change in religious belief and things like that. But here we're kind of looking at someone's relation to another person as the basis for cessation. The court also said that the security situation in the IPA in Kabul does not give rise to new grounds for refugee status, and that fact itself was sufficient for application of the cessation provisions. So as a consequence, there was an acknowledgement that the situation in Kabul had not significantly and fundamentally changed, but that as long as there was no new reason for refugee status arising from return to Kabul, that internal protection was acceptable. So the consequence of this for Farida and her family and for everyone else whose cases have followed the same reasoning is that they are returned to a situation of internal displacement to an insecure area, reliant on private actors of protection. And also that the children's situation in these cases are really given really little consideration. The court did acknowledge that Farida was sort of more susceptible to the risk of serious harm, but they didn't reconsider her best interest. In fact, under Norwegian law, the best interest assessment is kind of frozen in time at the point of the last administrative decision. So because that had been made in 2015, 3 years, 5 years have gone by without her evolving best interest being adequately assessed. So I'll conclude with just some reflections on kind of the major gaps and dilemmas I see here. As Gisela pointed out, there is a direct tension between security and predictability of refugee status, which the Norwegian courts have acknowledged is a purpose of refugee status, and the focus on eradicating risk in some area in the country of origin or previous residents. So there is very little attention paid to the quality of protection provided. And we've seen that not only clans in the case of Somalia, but private individuals have been identified as actors of protection. This, combined with a wide scope for return to an internal protection alternative, means that return in essence is not a durable solution as such, but implies, both in principle and in practice, a continuation of the protracted displacement situation. So a return to both immobility, because the scope of protection is limited to a specific area of the country, and insecurity because of both the external conditions as well as the dependence on private actors of protection. We see challenges with respect to children's rights, as I mentioned, best interests versus immigration control interests of the state, and also the fact that they're not assessed on an evolving basis. And also what I think is really important and really is rarely mentioned is the gender impact of cessation, both direct and indirect. I think, for example, we can look at whether women versus men may face different kinds of obstacles in achieving permanent residence, and therefore might perhaps be exposed to the possibility of cessation over a longer period of time. But also the consequences for women and also anyone with a gender-related claim to protection are quite distinct. If you can imagine, not only do we see in the Farida case and others that women are dependent on those private relationships with respect to the protection assessment, but also situations like refugees with status based on a domestic violence related claim or FGM or other kinds of traditional harms might really find it difficult to show that those same risks apply 5 years after they've first received refugee status. So I think we really have to question, is this the kind of thing that we want, that no kind of sense of stability is being granted to people who have fled sort of harms that are at least in part private. And I think Gisela's point about the intersectionality and the complicated nature of migration also plays a role here. And then, of course, the last dilemma really is what this means in terms of the possibility for inclusion. As I said, I think that the way cessation practice has played out really maintains a situation of protracted displacement, both in the country of asylum in Norway, because people are living with the possibility of cessation and revocation over extended periods of time, and also in the country of origin upon return to internal displacement. And in January of this year, the Supreme Court of Norway is considering the Farida case again, and will have an opportunity, I hope, to really think about the compatibility of the IPA with cessation practice, but combined with that, how all of these other issues play a role in terms of what the quality of protection is and non-state actors and children's best interests. So with that, I will conclude the presentation and look forward to questions in the question section, in the question and answer. Thank you. Next, we will hear from Nick, who will be presenting the Danish case.
Thanks, Jessica. It's lovely to be here among old friends. Really, I had a fantastic collaboration with UNHCR Northern Europe last year on another area of protection. And I'm a sort of inaugural member of the Friends of TemPro group, so it's good to be here. Look, I've got 10 minutes today to give you a brief account of Denmark's approach to cessation under the so-called paradigm shift. And of course, to unwrap for you what we talk about when we talk about the paradigm shift. And time permitting, I'll also point to some key research and policy questions arising from Danish practice in this area, both from a national perspective, but also I think from a more broad questions of international refugee law. So next slide, thank you. So the paradigm shift as a matter of law refers to a series of amendments to the Danish Aliens Act undertaken between 2015 and 2019. And of course, an important piece of context here is the influx of asylum seekers to all European states, but also Denmark in 2015. And the paradigm shift in its intention shifts the focus of international protection from a presumption of integration and permanent protection to one of temporary protection followed by return. Now, while implementation of the paradigm shift is still in a relatively early phase, the intent of the policy is clear. All protection should be temporary, and cessation practice in Denmark should go to the edge of Denmark's international obligations. So we're really seeing, I think, the Danish government sort of pushing the envelope as far as possible on questions of legality here. But to go back in time, so in February 2015, we saw the introduction of a new Article 7.3 of the Aliens Act, which introduces this temporary subsidiary protection status, providing protection from situations of general violence in the country of origin, rather than an individual fear of persecution or other serious harm. This status gives a 1-year residence permit renewable for 2 years, and of course complements Articles 7.1 and 7.2, providing for convention and complementary protection status under the Aliens Acts. Now, crucially, already in 2015, we saw the Danish Parliament make a distinction between convention status on the one hand and complementary protection status on the other. stating that there is a significant difference between standards for convention and complementary protection holders. So to my mind, Article 7.3 initially carved out a particularly sort of thin form of return-oriented protection for protection seekers fleeing generalized violence. And primarily here, we're talking about Syrians. The focus here, of course, was on providing a minimal level of protection in line with Denmark's Article 3 European Convention on Human Rights obligations. But the Parliament noted that specifically the situation in the country of origin, cessation would be possible even where the situation was serious, fragile, and unpredictable. So we're seeing a very significant normative gap between the standards of Article 1C and this new 7.3 of the Danish Aliens Act. This 2015 set of amendments was followed up in February 2019, following some years of calling for a paradigm shift as a matter of policy. In 2019, then the Danish Parliament introduced a final set of amendments that explicitly shifted the focus of protection from integration to return. So here we have the insertion of 19A in the Aliens Act, which provides a general provision for immigration authorities to end the protection of refugees unless such cessation would be in breach of Denmark's international obligations. The explanatory memorandum to the bill noted that protection holders would be subject to cessation for up to 15 years of legal stay. And of course, we have this interplay between Article 8 rights to family and private life entering at some point on the sort of integration scale. And of course, the maybe symbolic import of Article 19A is that in theory, not just complementary protection holders, but all refugees of all statuses are subject to cessation in Denmark. Now, in practice, what we've seen is that the majority of refugees subject to cessation have been in Denmark for less than 5 years, but that is in fact changing as a matter of practice. The next slide, please. So if we shift then from questions of the paradigm shift in law to what we see in practice, there's a few striking elements in the Danish approach. The first, as I've noted, is that the paradigm shift applies not just to certain classes of refugees. We've seen in Australia, for example, the application of cessation with respect to those who arrive by boat. But in Denmark, we see a blanket approach to all protection statuses, including convention refugees, including complementary protection holders, and has been noted by both Gisela and Jessica, we have seen small-scale cessation of resettled refugees. But what's interesting here and quite distinctive from Norway, I would say, is that cessation in practice has only been applied with respect to complementary protection holders. So we haven't seen the invocation of Article 1C, 5 or 6, but rather reliance on more negative rights related to Article 3 of the European Convention and Article 8 of the European Convention on Human Rights. A further important element of Denmark's approach is this relatively long, what I call a cessation window, whereby permanent residence can only be achieved in general after 8 years of residence. And this, in some distinction to other European states, really opens up refugees for cessation where they remain on a temporary basis after 3 years, 5 years, up to the 8-year mark. The next slide, please. So what we see here is a focus on two cohorts. Like in Norway, we see a clear focus on the Somali caseload. Since 2016, around 800 Somalis have had their protection ended on the basis of improved conditions in Somalia. In the majority of cases, cessation has taken place with respect to Somalis who've been in Denmark for less than 5 years. This is where the resettled refugee caseload comes in. But since the 2019 amendments, which really sort of pushed an explicit move towards cessation to the limit of Denmark's international obligations, we have seen a case or two beyond the 5-year mark. So for example, in this year, a 27-year-old complementary protection holder from Mogadishu, who had been in Denmark for 9 years, had completed Danish education, had permanent employment, and had a 2-year-old child with a Somali partner, was subject to cessation proceedings. And that decision was upheld by the Refugee Appeals Board, finding that while there were, of course, interruptions with this person's private and family life, that those interruptions fell within Denmark's Article 8 obligations. And I can only suggest that we'll be seeing more of these cases close to the edge of Article 8. The second cohort, of course, are Syrian complementary protection holders. Denmark, in February 2019, the Immigration Service released a country of origin report on the security situation in Damascus province in Syria. As a result of these generally improved situations, we saw 6 test cases in June of 2019, in which these 7-3 status holders from Damascus province were refused extensions of their residence permit on the basis that general conditions in the province did not rise to Denmark's Article 3 non-refoulement obligations. In those test cases, in fact, the Refugee Appeals Board overturned all 6 decisions, finding that the individuals involved did in fact have individual reason to fear serious harm because of their profiling. Now, while none of them were politically active, there were sort of a number of general factors that raised the profile of individuals who would be returned. So just for example, a civil servant who fled Damascus in 2011 while on leave from her employment was afforded protection in Denmark because she faced a real risk of interrogation and possible arrest if returned to that province. Now, what we've seen subsequently to those 6 test cases is 3 further cases in May 2020, where the Appeals Board in fact upheld the cessation decisions of 3 Syrians from Damascus province on the basis that neither the general conditions nor the individual circumstances gave rise to a need of protection. And we know, of course, that the immigration authorities are reviewing 900 such cases relating to Damascus province presently. So we can only expect more practice in this area and the ending of more complementary protection for Syrians in Denmark. So to move then to my next slide, to sort of zone out a little bit from the Danish case, I wanted to raise a few legal and policy questions arising from this practice, both in national context, but also perhaps more internationally. The first, of course, is this key question of, well, what sort of protection does Article 8 of the European Convention offer? So to what extent does the right to private and family life protect against cessation? Now, until this point, we've seen case law from the Strasbourg court mostly relating to migrants or refugees with a criminal conviction. So it's very difficult to, by analogy, use existing case law, and there may indeed be a test case emerging from Denmark in the coming years. But there is this very open question to my mind of, well, to what extent does Article 8 and when does Article 8 protect against cessation? The second, of course, is this normative clash between the permanent promise of resettlement on the one hand as a UNHCR policy-based program and the cessation practice of Denmark for the duration of risk only. And what we see here, I think, is that upon arrival, resettled refugees in Denmark are integrated into a general migration policy approach without any recognition of a particularly special status. And in fact, I would go so far to say that as a result of the paradigm shift, Denmark's resettlement approach is in fact more of a humanitarian admission program, given it is explicitly framed in terms of temporary protection. Thirdly, there is this more policy-oriented question about the link between cessation as a legal instrumental mechanism and return in practical terms. Now, both in respect of Somalia and Syria, Denmark lacks a functioning bilateral agreement on return. So there is this question about, well, what happens to people who are subject to cessation? Of course, there is a very strong focus on voluntary return, and that's been taken up by some, especially Syrians. But I'm particularly interested in this recent case law from the European Court of Human Rights in NA versus Finland, finding that notwithstanding a so-called voluntary return, Article 3 obligations do in fact bind the state. And the final sort of open question, of course, is, well, is Denmark simply an outlier in terms of cessation practice or some sort of front runner? Are we going to see a more aggressive uptake of cessation policies elsewhere, or is Denmark sort of out on its own in this field? On my final slide then, next slide, thanks. I'll just highlight a couple of areas for further research for scholars in the audience. The first, of course, is this question of a normative gap within the complementary protection framework. And we see that complementary protection has emerged as a really essential mechanism for the protection of refugees who fall outside the definition of Article 182. It's very widespread throughout the global north. But the Danish case, to my mind, reveals a sort of normative gap or a structural problem within some complementary protection frameworks. This doesn't apply, importantly, to the European Qualification Directive, which of course essentially states that cessation standards for subsidiary protection holders are almost on par with those of convention status. But where you have complementary protection frameworks built only on non-refoulement obligations, there are questions as to what other standards should be used if, for example, a state is not applying Article 1C to complementary protection holders. Secondly, of course, there's a need for research, and this is something Jessica highlighted on the practical impacts of cessation. Unlike Norway, I haven't seen research on the sort of more human impact of this practice in Denmark, and that's something that we Danish researchers need to address. And of course, I would like to raise this question of effectiveness. I mean, how many Somali or Syrian refugees subject to cessation will in fact return, or are they placed in return positions regularly, or indeed moving on to other EU member states? So there's questions of both human impact and effectiveness arising here. And finally, of course, there is, I think, a clear need for international guidance in this area. UNHCR's guidelines on international protection with respect to cessation date back to 2003. And a gap I would see is they don't cover this question of cessation of complementary protection. So I'm aware UNHCR is certainly aware of this need for an update in light of contemporary cessation practice, and really look forward to UNHCR's expertise on this really important issue. Thanks very much. I'll stop there.
Thank you, Nick. That was excellent and concise overview of what the situation and challenges are in Denmark. Now I'll turn to Jens. I know we're running a bit short on time, and I think we'll just continue with our two comments, and those who are able to stay for the Q&A session afterwards, we'll just continue until 12 p.m. Yeah, Jens.
Thanks, Jessica, and thank you to Gisela, Nick, Jessica, and Peter for interesting, really interesting presentations. I'll try to squeeze my comments a little bit due to the time, but I think it's interesting to notice that we have both similarities and differences between the three Scandinavian countries. One of the commonalities is probably, at least between Denmark and Norway, that we see in various settings, we see attempts to stretch or bend international law. I'll come back to that based on Nick's presentation for Denmark, but in Norway, I'm not familiar with the Norwegian case law in detail, but as Jessica presented it, I think it'll be really interesting to see whether the Supreme Court will uphold this individualized interpretation of circumstances in connection with which in Article 1C5, that is quite fascinating actually. And it will be interesting to see whether that holds. I would say it seems to be an attempt to bend or stretch the wording. and the substance of that cessation clause. For Denmark, as Nick eloquently explained it, we have another attempt. I think Nick talked about the window, not of opportunities, but a window of cessation or revocation, which is a bit imaginative in one way, based on the preparatory works of the paradigm shift legislation from 2019, where the policymaker, by way of sort of explaining in the preparatory remarks how the more or less non-existent Strasbourg court practice should be understood, or rather should be implemented. They are sort of trying to take advantage of a kind of normative gap, as was the term suggested by Nick. And this, I think, is really interesting. As Nick said, Denmark is now essentially focusing, when it comes to revocation of the subsidiary protection permits, it is focusing on the minimum Article 3 obligations. And here we have an interesting issue, I think, because it simply illustrates the problem that also Peter was talking about, with this differentiation between convention status and the various kinds of complementary protection. In fact, sorry, what has now become the threshold for revocation of subsidiary protection permits in Denmark is a kind of an application of criteria for inclusion under Article 3 of the European Convention. Since these three terms, that there can be a lack of protection against refoulement despite a serious, fragile and unpredictable situation, are in fact used or have been used in cases concerning applications for asylum. First, the Swedish KAB case from 2013. And that is at least remarkable, that we are using inclusion clauses, which in other words is lack of protection against refoulement, in order to bring an already existing protection status to an end. And here I think we could consider whether a good faith application of the protection obligations under also the European Convention wouldn't require some kind of stability or effectiveness condition to be fulfilled. This has to do with presumptions, and I think what becomes clear now is that under the Refugee Convention there is a kind of presumption that protection need will persist until you can prove the opposite. While it seems to be more or less the other way around for Danish law and practice now, that there is a presumption that as soon as you can prove or indicate that the need for protection in general terms has come to an end, then the individual need has also ended. And it is terribly interesting to see the way in which the Refugee Appeals Board is and will be implementing this threshold for revocation of subsidiary protection permits here, because it somehow is based on, I would say, a kind of fiction, which is the distinction between individual and general circumstances being the basis of the need for protection. And this in itself is an interesting and potentially distorted approach, I think, to assessing asylum claims. How can you really, in particular maybe in the Syrian conflict situation, how can you differentiate between individual and general circumstances or risk factors? I think it may in some instances turn out to be a rather absurd or impossible distinction. In more legal terms, this also raises questions of discrimination, obviously, whether it is sustainable to operate such differential criteria for upholding protection status for the various categories of persons in need of protection. Also, given the fact that we know that the distinction in inclusion under the various statuses is sometimes somewhat arbitrary. Just compare across EU member states, you'll also find that the similar categories of refugees are being granted quite different statuses. So, and even from Danish practice, I think everyone who has been involved knows that it can be quite arbitrary, or at least unpredictable, whether a given case will be referred or subsumed to a convention status or subsidiary protection status. So I think we have interesting things here to follow up on in terms of both the feasibility of the distinction and the legal tenability of this potential discrimination between different categories of protection beneficiaries. My third remark here would also has to do with the last observation on discrimination. That is simply the differences in protection standards that have been applied in Denmark between the various categories. The most important issue here is, of course, the suspension of rights to family reunification for those having the temporary protection status. As you may know, there have been cases concerning this 3-year suspension rule before the Danish courts. Their approach has not been impressive. I would say it wouldn't be unreasonable to say it was fairly obedient to the legislative intentions. And interestingly, the Supreme Court availed itself of the margin of appreciation, which is normally the domain for the Strasbourg Court. So therefore, it'll be interesting to see what the Strasbourg Court will say to this. We are actually awaiting the first decision, as you may know, in the case MA versus Denmark, which was negotiated or in an oral hearing, I think in May or June. So the judgment may be soon forthcoming. And it'll be interesting to see how the Strasbourg Court will approach both this tendency of suspending family reunification rights more general, and also as a quite adverse factor, maybe the fact that the Danish Supreme Court has already granted the legislature this margin of appreciation. So how should the Strasbourg Court deal with this? Can the Strasbourg Court repeat the margin of appreciations, so to say, which effectively means that there has been no intensive or thorough judicial review at the end of the case if the Strasbourg Court also grants a margin of appreciation. So it'll be really interesting to see. I think given the time constraints, I think I'll stop here for now. Thank you very much.
Thank you, Jens, for this excellent comments. We'll continue with Maria.
Thank you, everyone. That was really fascinating. And just coming back to a big picture perspective, I guess, to draw all these themes together. One thing I'd like to note is that cessation perhaps can be used as a deterrent. And I come to this from an Australian perspective where we always think about deterrence. So we have offshore processing because it's a deterrent. So this goes to the point that were made by some of you earlier about, you know, the time it takes to states to actually do this. Why are they doing it? Because it's so resource intensive. And I just put it out there that might be the underlying or explicit rationale. And just quickly, as we're running out of time, I just want to flag 3 things. The interpretation of the Refugee Convention. Obviously, it was drafted in 1951, where we didn't have ideas about IPA or non-state actors. So for me, the big legal question is whether we take a literal interpretation of the convention, or in your case, the EU Qualification Directive, or do we take a more purposive interpretation? And that goes back to this idea of taking a modern day interpretation. Do we apply principles about non-state actors? Do we allow or oblige former refugees to go back to a country like Afghanistan, where the security of the situation is being upheld by multinational troops, something that was not foreseen back in 1951. And that really goes back to something I think that some of the earlier commentators were talking about in terms of personal circumstances. Again, that doesn't really factor into a lot of the jurisprudence here in Australia, where it's very much, what does the Migration Act say? and we apply a statutory interpretation approach. So I thought that was interesting that you were talking about personal circumstances, because I think there's a reluctance by states to take a humanitarian approach to the convention. Again, you know, even in the United States and Canada, it's very much what does the convention say, its text. And they will only stretch that a little bit for humanitarian purposes. And that also goes back to looking at what UNHCR says as well. And by the way, Australian courts pretty much ignore UNHCR amicus curiae, but that's another story. Going briefly then to the interpretation of 1C, and this goes back to Jessica's point about IPA. I don't think IPA should be a part of cessation, and that's because I don't think cessation is a mirror of recognition. Again, this goes back to UNHCR guidance on this and some jurisprudence. This very core argument about what cessation is. Is it literally the mirror of recognition, or is it something else? And I argue in my book that indeed it is something else. You have to show effective protection. And why is that? Because once you've been recognized as a refugee, you almost get a special status. And that can only be withdrawn if there is a higher standard. It's not just absence of persecution, but effective protection. And then lastly, in terms of some contextual things about the insecurity and predictability of refugee protection, again, this may go back to looking at problems with the Refugee Convention and the fact that permanent residence for refugees was never part of the provisions. All we really have is Article 34 of the Convention, which, as we all know, only encourages assimilation and integration of refugees. So they're my comments. Thank you.
Thank you, Maria, and thank you, Jens, for really excellent comments that were able to bring together some of the key trends. I'm going to turn it over to Olivia, who is going to moderate, for those who are able to stay for a few minutes, some of the questions that have come up in the session.
Thank you, everybody, for these excellent presentations. We did receive some questions. I will get first one question from Hannah. And actually that goes back to Jessica's presentation, and she's interested in particular to learn whether the Norwegian authorities assessed whatsoever the child's best interest in this case. And she assumes that she indeed formed private life here in Norway and went to school, and then in the end she was obviously returned to Afghanistan because the Norwegian authorities applied a cessation clause. And obviously we are familiar ourselves with the facts of this particular case because UNHCR did intervene in the case. But Jessica, if you would like to add something, and in relation to this, I would also follow up with a question to Maria. Would the situation that Hannah addressed, could that be solved in some way about the compelling circumstances proviso in the Refugee Convention? And that also following up on what you say that about the humanitarian approach, that states aren't reluctant in general to do that. So Jessica, first to you, and then going to Maria.
Thanks for the question. I won't repeat what I said in the presentation, but just to point out that a child's stability of their situation is a factor considered in Norwegian legislation under the best interest principle, but best interests are not assessed until the consideration of whether there are humanitarian grounds to remain in Norway. So I would say that that the integration of children's rights into the cessation analysis is very weak and extends probably up to the point of assessing having a child-sensitive analysis of whether a continued protection need is there rather than anything else. Norwegian, the instructions do note that the compelling circumstances, it's something we haven't really discussed, exception to cessation may also relate to children, that children might have compelling circumstances for not being subject to cessation, but in the research I've done on this, this hasn't been used at all in practice. And so in the Farida case, the fact that she has basically been in this situation of uncertainty for 10 years, it isn't legally relevant because her, first of all, best interests are kind of watered down by their position in immigration law, and also the fact that they're determined at the point of the final administrative decision to revoke a residence. So the fact that all these appeals have happened after that administration decision doesn't mean that her best interests have been sort of reassessed in that case.
Thank you for the questions about compelling circumstances. So for those who are not aware, there is an exception to cessation in the Refugee Convention. Now, unfortunately, it does, strictly speaking, apply to pre-1951 refugees. I believe that's been remedied in the EU Qualification Directive. But looking again at comparative practice in Australia, we don't recognise that compelling circumstances exception because it relates to pre-1951 refugees. So again, we take a very literal approach. And in fact, there have been a number of cases in Australia where people have been resident here for 20 years. And so there are compelling circumstances for not returning them to a country where they have never lived. There was a man who came over as an 8-year-old from Vietnam back under the Comprehensive Plan of Action, and he was returned. Now, that was part of a criminal deportation case as well, but that gives you an understanding of how other states are applying or not applying the compelling circumstances exception. Again, this is where we get the difference between the UNHCR approach, which says we should be taking this humanitarian interpretation of the convention. Obviously, we shouldn't be taking a literal interpretation, but I would just flag that that's not a universally accepted principle.
Thank you so much, Maria and Jessica. The next question is from Jerome Alley, and he wants us to, and one of you, to explain whether and what relationship and dynamics exist between Article 1C1 and 4-4 and 1C 5-6. He presents his assumption here and a semi-answer. He inquires whether 1C1 to 4 are clearly, I mean, he presents the answer that they're the basis of durable solutions, and whether putting an emphasis on cessation under Article 1C 5-6 are basically reducing, is basically a way to reduce the focus on durable solutions. And he asks you, the specialists, the experts, whether you agree or not. Gisela, I was thinking to give this question to you.
Yes, and I'll try to answer it. Well, you know, the broad durable solutions context of the 1951 Convention is, of course, important to bear in mind when interpreting the cessation clauses as well. Really, perhaps apart from Article 1 of the Convention, which is often the one that we mostly talk about, the Convention is really about durable solutions, right? Although this word is not mentioned explicitly. You know, the Convention foresees a gradual attainment of rights over time. Article 1C talks both about return, right? Re-availing yourself of the protection of your country, as well as local integration. When acquiring a new nationality, it's most often the nationality of the country of asylum. And then we also have Article 34 about naturalization, as you mentioned, Maria, at the end of that spectrum from arrival through to full integration. But when looking specifically at Article 1C, indeed, 1-4 deals with personal circumstances at the individual level. So the individual acting voluntarily, whereas 1C 5 and 6 have for decades been understood to be about fundamental and durable significant changes in the country of origin. And most often they have been applied on a group basis. You know, after 10 years or 20 years after the genocide in Rwanda, for example, the end of the internal conflict in Tajikistan. It's situations like this where 1C5 and 6 have been applied. It's only more recently that they have been applied to individuals, and then even more recently to a change in personal circumstances. But they are not meant to, chase after refugees and subject them to regular reviews each year or every second year. Refugees are entitled to a stable and secure status after, their experiences of persecution and flight. So, it is important to always bear that. That's the rationale of the convention.
But I just say quickly too, sorry, that, we're all, practically speaking, when someone is adjudicated for cessation, this is a problem with Article 1C5 and 6 is about country information. And at least in Australia, the NGO community has been very concerned about the quality of country information, particularly if we're using US Department of State reports. So I would just flag that, to me, is the central problem with Article 1C5 and 6, that you're dealing with country information, which is very subjective and not always reliable.
Thank you. Thank you so much. And we do have another question to Peter, and it concerns the Swedish practice. And I'm just going to read it straight out to simplify it for everyone. In or around 2012 and 13, the Swedish Migration Agency developed their own practice and granted temporary protection to subsidiary protection holders from Syria. Those are convention status refugees, as opposed to convention status refugees receiving permanent residence permits. Are you aware or whether there were any cases of cessation during this time period, which might be indicative of what types of practices we can anticipate from the Migration Agency under the revised Aliens Act? So you will have to look into your globus, Peter, and speculate a bit based on your knowledge about the Swedish practice. So go ahead.
Thank you, Olivia, and thank you for the question. As we're really running out of time, I'm going to be very brief. I mean, the short answer to this is no, there are no such cases. And as Maria was just saying, this is really a question of assessing the security situation in the country. And in this case, the latest judicial position on Syria clearly, from the Migration Agency, clearly sets out that while the security situation in Syria has improved, the changes are not of such significant and non-temporary nature that cessation would be merited. So this assessment will remain until the Migration Agency changes its view on the security situation in Syria.
Thank you so much, Peter. I cannot see any other questions. Was there anything else, Jessica?
Yeah, there was one other question from Sarah about the legal distinctions. Let's conclude with this. This is question, legal distinction between cessation and revocation. Is it upheld in Danish policy and practice? It strikes me that the term often used is inddragelse, not bortfall, which I understand to be mudding of the legal terms. I can say in the Norwegian context, there is a definite muddying of the legal terms, and case by the Immigration Appeals Board from, was it just this summer? Yeah, actually, that tried to distinguish cessation in cases involving people with criminal records from other cessation cases, saying that they do not have a right to sort of a predictable and stable status because of what they've done, basically, and applied the kind of mirror approach, looking only at the current risk of persecution in those cases. So definitely the answer is yes in the Norwegian context, but I don't know about the Danish one.
Well, as to the details in Danish law, I can send an email to Sarah to try to explain a bit, to save time here. But let me just try to say that in this European Migration Network report that you mentioned, Jessica, and which is also linked on the CMI website, we tried to clarify concepts a little bit. I think actually that is terribly important, because there's often a need to distinguish between domestic and international law, and there are certainly differences between various terminologies across countries in national law. One thing in particular I think is relevant to keep in mind, that is the special nature of cases concerning expulsion of criminals. I would suggest that we simply do not consider this as a matter of cessation. It may technically result in the revocation or lapse of the residence permits under national law, but I think under the convention, as Gisela also explained, criminal activity is generally not a matter which can affect the refugee status. There can be the exceptions you mentioned in Article 1F, A, and C, but all sort of ordinary non-political crimes cannot per se affect refugee status. They may result in lapse or withdrawal or expulsion affecting the residence permit, and that can then trigger issues of protection against refoulement as the ultimate assistance to save people from that, but it is not affecting refugee status as such. And therefore, I would suggest that we don't mess up conviction of criminals and consequent expulsion with cessation of refugee status. I think it will help ourselves for both conceptual and more strategic reasons to distinguish clearly here.
I agree, Jens, and I think it's just another example of how in state practice there's this increasing tendency to make distinctions between refugees in an effort to kind of expand the scope for revocation and deportation. So on that note, I would just like to thank everyone, thank all of the participants, and thank the panelists, the commentators, for joining us today for this really interesting discussion. And that I hope that we can continue this. There's so much that we haven't unpacked yet, so it just goes to show that this is a rich area of practice in refugee law, and there will be a lot to think about and try to understand better in the years to come. Thank you.
Thank you. Bye-bye.
Bye.